Audience, you can raise your questions if you have any for Shri G R Raghavender ji and Mr. John Cabeca. Anyone? Yes, please.
Hello. Mentioned there's a tremendous focus here in India to support early stage entrepreneurs, help support startups and help them on their path. And I come from Silicon Valley. I used to run the Silicon Valley U.S. Patent and Trademark Office, and I worked with startups, and I know that typically the very first type of intellectual property a startup has is a trade secret, right? They're still in stealth mode. They're still advancing their products, trying to get investments, and it's a complicated and very fragile time for a new and emerging enterprise. So I do think that there's sufficient amount of desire here. Again, this isn't something that just benefits the U.S. It really benefits the Indian businesses tremendously. And we've had several discussions about it, and I believe we have some more planned. And I think that I don't know where the status is on actual providing proposed legislation, but I hope it's soon. Unless do you have a comment on the status? Okay.
As you know, the National Intellectual Property Rights Policy in 2016 does advises that India should explore the possibility of introducing a standalone sui generis trade secret law. And some efforts have been done by FICCI and others, creating a kind of policy paper, concept paper, seeking comments. But what I say that the stakeholders, especially the startups or various industries, should think about this, and through their associations, they should approach the government and explaining the need of this. Unless and until patient go to the doctor can't get prescribed the medicine. Yeah, that's.
Can I just add one more thing to this? So it reminds me of something in our own practice where we once had a committee hearing before Congress to discuss a procedure that we were looking to implement at the USPTO, and it specifically dealt with our post-grant patent procedures. And it was a great committee hearing because we had representatives from small businesses, large businesses, biotech, high tech. We had both sides of our government present, and everyone was in agreement that this is something that we should do. And when I say these are complex issues, it still took us 7 years to get legislation on it. So it's one of those things where it takes. I would love to see the more forward momentum on it, because even once there is momentum and work on this, it is still going to take some time to get through the system to have effective legislation in place.
So I have a question for you, John. So we talk about the economies, and we talk about the countries which have a highest level of respect for IPR. So just wanting to understand your viewpoint, what these countries have done, what the judiciary has done, what is the role of government in those countries, and why the IPR is at such a high vis-a-vis the other countries. So if you can just throw some light on this.
So it's a good question, and I'll share just from my own personal experience. So I've been at the Patent and Trademark Office now 33 years. So I started as a patent examiner. And back then everything was in paper. I had to, paper files. I had to search in paper. I used to have to handwrite my office actions and then turn them into a typist to type. So it wasn't that long ago, but it seems when you look back now, at the way we work, and not just the technological improvements to make our jobs more efficient, but just the amount of effort we put into our work products in clarifying our positions on the record, so many aspects of the way we work, not to mention our laws have evolved over that time. If you look back 30 years, which is longer than India's had a patent system, right? You know, that transformation has been tremendous. And so what I think the takeaway is, even though I was there every day, I can't point to one specific day where all of a sudden, you know, yeah, one day there was a computer in my office, that was great. But where there was like this sweeping change in our law that made us totally do a 180 in how we worked. That's almost an impossibility. If you think too big about some big overarching massive reform, it will never get done because it's too complex. But our success, I think, is based on many incremental changes. And we're not afraid to test things in our system. We pilot programs, and we just announced a new pilot program just a few weeks ago. So we're constantly testing systems to see what can we employ to make our system more effective to the rights holders. What are some steps that, you know, now with new advancements in technology, are there things that we can use that technology for to help us do our job better? Can we use AI in helping our patent examiners search? Can we use AI with customs officials and police officials to find counterfeited products? So these are things that we're exploring. And I think that the takeaway is we just never stop exploring.
Now passing the question to Sir. Sir, on the similar ground, when you are in system, so we know that there are best practices across the globe. So is there a way that we can customize those best practices and bring them to India so that the respect for IPR per se increases? If you can just enlighten the audience on this.
Yeah, we do that in the policy making, because with my experience of amending the Copyright Act, introducing the bill in 2010 and getting passed in 2012, best of the best practices we adopted. For instance, there was a big issue about the sharing of royalties for the authors and composers, that is underlying works, performing rights. You know, the world best practice is sharing the 50%. That was the CSAC, 129 countries, it's in the practice. It's a business practice, which it was not respected in India. And then Rome Convention says, Article 12, if business fails, that can be introduced in the law. So we introduced that in the law. And similarly, you know, there is a possibility of either influencing them to not to claim for that royalties. So we took the German concept of right to receive royalties. We introduced not only for author composers, but performers. And then we did not stop there. We exported it when we trying to revive the Beijing Treaty with my US colleagues. When Professor Justin Hughes and myself and other colleagues from Mexico, the first draft we drafted, and we got it to the diplomatic conference. There I included the same Indian text language, right to receive royalties. So you can see the Article 12 of the Beijing Treaty and the Indian copyright provision. You see the similarity in the phrase language. So we take the best languages. Now we started a language of not only the importing, exporting also.
Good morning, everyone. I'm Runjun. I work with the organization called Medicines Sans Frontiers, also known as Doctors Without Borders. So my perspective will be completely from the access to medicine, or how all different concepts that we have spoken till now, starting from TRIPS flexibility and how TRIPS waiver was totally not required when we already had TRIPS flexibility in place. And also then connecting to the Tracer 01 report, which comes every year and has India in the list. So in spite of the fact that we have TRIPS flexibility, my question to Sir would be how many times we have actually managed to issue CL, compulsory license, for different, for different aspects or areas where we really, really need it in terms of access to medicines, because pharmaceuticals literally is the whole, the elephant in the room kind of. Then second comes in 301 report, a couple of points that really, kind of puts the whole thing on in focus is pre-grant opposition or post-grant oppositions delaying the whole patent, issuing patent and stuff. So just to quote some data, annually we file, we process or examine 50,000 patent applications in Indian Patent Office, whereas only 400 applications or pre-grant oppositions are submitted, and out of which only 1% actually goes through the hearing and process. So is it actually the pre-grant opposition or post-grant opposition which is delaying the whole patent status, or is it the lack of human resource in Patent Office which is not able to process the applications faster? And then another key legal provision which is constantly being attacked in the 301 report is Section 3D. If we look at the different court cases where this has been challenged, we see, especially again in pharmaceutical, the attempts of evergreening has become very common. And when we have had these cases, when the courts came up with judgment which says this is not patentable, we had reasons for it, and it's a reason, like nicely defined reasoning for those judgments. So at least I just want to know, both from Raghavender sir as well as you, while we keep talking about that we have flexibilities that countries should be using, and that's why there's no more need for different provisions or different attempts, how many times we have actually used it? And for a country like India, and how do we see 301 report as a measure, not going legally, but more like the bullying tactic of the IP-intensive countries? Because we have not managed to use it when we really need it. Right now, in COVID, we didn't manage to do it. And even today, India being a high-burden country for drug-resistant TB, we have so many patients dying. There's a court petition in Bombay High Court for issuance of compulsory license for two drugs called bedaquiline and delaminate. Bedaquiline is from J&J, and delaminate is from Japanese company Otsuka. While number of drug-resistant TB cases are increasing, and as we all know, it keeps going on, it multiplies, and we are nowhere close to the 2025 goal of eliminating the disease. The courts have not really come up with any position. And somewhere it feels like while we have provisions, we as a country, we have not managed to use them. And hence the waiver was one of when COVID was a situation where we really needed to save people's lives. And maybe, in some ways, I understand that we have to have a trade relationship and we need to have favorable situations. But again, as government, we also need to see for whom we are working for. Is it a handful of industry that tries to regulate, or are we concerned about people who die due to lack of access? Thank you. I have a lot more, but I'll keep myself limited to that.
Coming to 3D provision, it was introduced to stop the evergreening of patents. It wasn't drafted in the forums of all of the ministry, but with the intellect of all the legislators sitting in the standing committee of the parliament. So from left, right, center, everyone contributed, and unanimously they supported this for the access to medicines and promotion of generic and affordable medicines in India, so that patent cannot be extended with the evergreen, number one. And that will stay. That won't be removed. As long as patent law is there in India, TDD will be there. Number two, coming to the compulsory licenses, and not only the 31 article, all the flexibilities have been used, and India played a key role in amending the TRIPS agreement and introducing 31 bis, Article 31 bis. But that has come with a lot of conditions. In implementation, it won't be satisfactory. That is the reason why, again, India took a lead to submit a proposal for the TRIPS waiver. Knowing that present compulsory license provision and the amendment to that 31 bis, both will not suffice. So we wanted. But unfortunately, things went in a different direction. Finally, this kind of waiver, we have got it. But there is no end, but it is not the final, and then future negotiations will continue. And then coming to pre-grant and post-grant opposition, that will also continue, because that is as per the TRIPS flexibilities and satisfaction. I don't think that is in public interest has been introduced. And again, compulsory license, why new compulsory license have not been given? Considering the COVID situation, and making new medicines accessible to them. And we have to see the entire gamut of that principle concept of whether such patent is working. You know, there are different experts give that different interpretation. And then finally, in public interest, government can do, but it all depends how the CGPDTM office, the person sitting there, the expert sitting there react. Because I can't answer on their behalf. Thank you. You want to say something?
So I think, when it comes to 3D, and we have a mechanism very different in the US for ensuring that an innovation does not, and follow-on innovations don't extend beyond the original patent term. And we have a whole system for ensuring that doesn't take place. And I think ultimately what it boils down to is how 3D is being interpreted, and having in the examining corps ensuring that and also in the courts, that you're getting predictable, consistent, and reliable results. And I think that that's one of our big concerns with 3D specifically. Is there, for every decision you mention in one direction, there's another in another direction, and that happens in our court systems as well. So, I don't think there's much more I have to say about that. On the other issues, I think ultimately though, and obviously you said it's all about pharma, and that's your life, right? But there's also high tech, and there's small companies that we're trying to support, and there's other enterprises, and there's emerging technologies. And a strong and effective IP system is one that balances across all of these technologies and doesn't tilt the scale one way or another. And we work very hard to maintain that balance. And that's what all IP systems should do, and I think try to do. So I'll just leave it there. I think if you look at the own High Court's rulings on their opinions recently on pre-grant oppositions, in one case delaying 19 years, kind of answers the question for you, I think. Okay. Yeah. So, there's very few that are, yeah.
Recently, Supreme Court sat on a case for 16 years and remitted that case back to Allahabad. You know, we can't say that all cases pending for 16 years.
So we have an expert, Mr. Vivek Sehgal, OPPI Director General. So, sir, do you want to comment on this question, or
I think I'll cover that
in your session?
speech. Yeah.
Okay. Okay, good.
Yes, one more question. Please provide the mic.
My name is Mohit Mahajan. I'm Managing Director of an NGO called Center for New Product Development, Trade and Transfer. My question is regarding the IPR policy, the 2016 policy of India. Right in the objectives, it states that India stands to promote frugal innovation, since that is one of the that is identified as an area of expertise, particularly in the manufacturing. By saying this, it seems like it has put its cards in favor of flouting any kind of IPR legislation. When it says that when it comes to manufacturing, we will adopt frugal means of doing manufacturing. How do you reconcile it with anything that stands for doing IPR and vis-a-vis anything which is done in a frugal way? Thank you.
And I don't think that phrase will allow, infringement of any IPR, whether it is patent, design, trademark, or copyright, or other intellectual property laws in force. So, it cannot be read as a kind of confusing interpretation. It's not a oxymoron kind of thing as well. Thank you.
Thank you. So this was the last question for this session. Now I would request you all to please proceed for the tea break, and we'll resume after 20 minutes. Yeah. So let's resume for the tea break. Thank you.